Case number 23 CR 126, State of Ohio versus Trenton A. Zumwalt. Present for the state's Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Danielle Witt. And are you Trenton Andrew Zumwalt?
Yes, sir.
All right. The defendant entered a plea of guilty to having a weapon under disability, a third-degree felony. The matter was referred to the Probation Department for a pre-sentence report, which I have reviewed. Each of the attorneys had an opportunity to review a summary.
The state has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. I'll start by pointing out that this is the defendant's fourth felony conviction. He also does have two prior numbers. In reviewing the PSI, the defendant may indeed have a substance abuse problem, but it also is clear that he has a gun problem. He has a prior conviction for weapons under disability in Clinton County back in 2018, was sentenced to a term of incarceration in that case. In the instant case, there was an allegation that the defendant was involved in an argument with another male subject, I believe it was a roommate, and during that argument, the defendant pointed a gun at the male's head. I would also note that this defendant does have two prior convictions in this court for trafficking in heroin and possession of cocaine. In that case, he was sentenced to prison originally. He was granted judicial release, violated community control in less than a year after being released, and was in order to serve the balance of his prison term. So based upon the defendant's criminal history, the specifics surrounding the charge in this case, it is the state's position that a term of incarceration is appropriate. Thank you, Your Honor.
All right. Ms. Witt, on behalf of the defendant.
Yes, Your Honor. We asked the court for community control with the condition of his continued treatment. Since before the first pretrial, Trenton has been in treatment and doing well. While yes, as Mr. King stated, he is a repeat offender, and since initially meeting with him, I do see a change in him, and he has actually taken accountability, and I'm quite possibly for the first time in his life taken accountability for what he's done, and knows that continued path will not get him anywhere. I know that he has put a lot of thought into what he wants to say to you today and to this court today, so I will let him speak for himself as far as the changes in his accountability. Had it not been for the weapons part of his charge, I feel like he would have been an excellent candidate for a drug court, but since he's not eligible for that, just ask for the opportunity to continue in his current treatment and doing well.
All right, Mr. Zumwalt.
I extend my sincerest apologies to everyone for any wrongdoing and inconvenience caused by the charges brought against me. I acknowledge the gravity of my actions and the impact they may have had. Prior to this incident, I had been maintaining a relatively stable life, though I must admit I was still struggling with substance abuse. Following a separation from my children's mother and the subsequent move in to live with my brother, I made the regrettable choices that led me down a negative path. I am genuinely remorseful for my behavior and the consequences that ensued. However, this situation has presented me with a valuable opportunity for self-reflection and personal growth. I seized the chance to break free from my past by relocating away from Highland County, which has proven to be a wise decision, helping me steer clear of further trouble. In an effort to address my substance abuse issues, I voluntarily enrolled in a treatment program in Ironton, Ohio. Since then, I have remained committed to my sobriety, strictly adhering to all program rules and local laws. This journey has been transformative, representing the most significant progress and positive change I have experienced in years. While I do not oppose facing the consequences of my actions, including the prospect of probation or other stipulations, I humbly request the opportunity to continue down the path of personal growth. Having been incarcerated in the past, I understand the seriousness of the situation, but I genuinely believe that additional time behind bars would hinder rather than assist me achieving my future goals. I respectfully urge Your Honor to consider not only my previous convictions, but also the progress and commitment I have demonstrated towards rehabilitation. I am prepared to accept responsibility for my actions and will abide by any decision you make. Thank you for your time.
All right. Anything further?
No, Your Honor.
All right. Well, there's no doubt that there's a substance abuse issue here. It's very clear, but concern that the court has is about the behavior and the danger that is caused in this situation. And also, I don't find that there's a true accountability here, because Mr. Zumwalt has claimed he didn't know how the guns got there and continued to deny that to the officers as well as to the probation officer. And clearly these guns were stolen from his girlfriend and ended up in the house. And, you know, he is the only one, he's trying to blame it on everyone else. And then said that in the PSI that interview that, you know, he had got caught in the middle of the problem. And so there's not true accountability. I think that that it's admirable that you've done some work on substance abuse disorder. Hopefully you're doing it for the right reason, that you want to be clean, not simply to stay out of trouble and not go to prison. But the court's looking at the fact that these guns were stolen. You know, there was one that was pointed at Mr. Jones, and that you continue to deny any knowledge about how the guns got there, or that you actually even possessed the gun. And so, based on that, the court finds that that this is not an appropriate case for community control. So it's the order of the court that you be and are hereby sentenced, I need the jail time credit, to the Correction Reception Center at Orient, Ohio, for a period of 18 months, and according to the sheriff, your arrest on the 29th of May, released on the 5th of June, so that would be 8 days of jail time credit. Now, upon completion of the sentence, it is possible that the Adult Parole Authority will place you under post-release control for a period of up to 2 years. They don't have to, but they can if they do. You'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have failed to comply, then they can return you to prison, make you serve an additional period of up to 9 months for any one or more violations. That's the cap. However, if you commit a new felony, then in addition, whatever sentence a judge in the new case could impose upon you, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of a year. Whatever time's left on that period of post-release control, whichever is greater, if that occurs, that must be served consecutively sentenced in the new case. You're also ordered to pay the court costs, for which judgment grant execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, you can do community service in this county and be given credit at an hourly rate set by the court for each hour you work. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
You're remanded to custody, Mr. Zumwalt. Ben, this lady over here has a cell phone. She was scrolling on. She needs to turn it off. Okay.
Matter of fact, Your Honor.
All right, you may. Christina Cassidy. All right, this is case number 23 CR 156, State of Ohio versus Christina Cassidy. Present for the state's Assistant Prosecuting Attorney King. Present for the defendant's attorney William Armentrout. And are you Christina Cassidy?
Yes, sir.
All right, Ms. Cassidy has entered pleas of guilty to counts 1 and 2 of aggravated vehicular assault, both second-degree felonies. This is a matter. This matter is a sentencing hearing. The court ordered a pre-sentence report. I have reviewed the summary, and of each of the attorneys had an opportunity, or I've reviewed the report. Have each of the attorneys had an opportunity to review a summary?
State
Yes, Your Honor.
All right. Now, Mr. King, the victims of the offense has been notified of this hearing, time, place, and purpose, and the opportunity to be heard.
Yes, they have, Your Honor, and Mary Jo Neiman is present in the courtroom today.
All right. All right, anything from the state then regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of 4 years incarceration on each count to be served consecutively. This is a case where the defendant stole a vehicle, proceeded to drive that vehicle through a fence, entered the roadway. As soon as she entered the roadway, she went left of center and struck a Toyota Prius head-on. The driver of that Prius was Gregory Neiman, and the passenger was his wife, Mary Jo Neiman. As a result of the collision, Gregory sustained multiple rib fractures. Mary Jo's injuries included a broken neck, a broken fibula, and also a broken ankle. The defendant at the time of the crash was under the influence of alcohol and also had a suspended driver's license. So based on the circumstances, the state feels that that would be an appropriate sentence. These charges do carry mandatory prison. There is restitution in this case, Your Honor, to Mary Jo Neiman in the amount of $682.92. And Mary Jo is present in the courtroom today and would like to make a statement if the court would permit.
All right. If you would stand and state your name, please. You can speak from there.
Yes, Your Honor, thank you for allowing me to speak. I'm Mary Jo Neiman. Would you allow me to read my statement in my...
Sure.
Okay. As you're well aware, that on March 25th, Greg Neiman and I were in a serious accident, a collision with Christina Cassidy. Under the influence, she did make a choice to steal a truck, speed away, through a fence, and hit us head-on as we were doing our daily activities. Due to the choices she made, we were seriously injured. Mine and Greg's injuries have caused tremendous hundreds of thousands of financial dollars, emotional injury, and physical harm that personally I and Greg will never totally recover from. The burden her choices have put on my family during that time, caring for me, caring for my brother, who I was supposed to be caring for, who's 86 years old, caused a lot of emotional and financial burden on them. They had to miss work. They came over and took over my responsibilities. That will always, Your Honor, be on my heart to try to pay them back. But this has not only affected me, Your Honor, this has affected Christina, her family, and her children, and I want her and you to know that that is on my heart. I would like to see her be a productive member of this society and be a parent to her children and be productive in her life and get over her, be rehabilitated from her substance and emotional issues. In your choosing, Your Honor, to sentence her with whatever is going to be chosen, I would like you to consider full rehabilitation opportunities for her in the facility she will be in to help her become a productive person in society.
Thank you.
Thank you, Your Honor.
Anything else, Mr.?
No, Your Honor.
All right, Mr. Armitrout.
Your Honor, on behalf of Christina, appreciate your words, ma'am. I know that you were seriously injured, and my client has taken full responsibility for it, Your Honor. She's been an excellent client to me, never made excuses, acknowledged her. Actually, it was a long-term alcoholism. This was just a culmination of a horrible set of events. She did enter a rehab on her own right after this, and it was not in any way to enhance what the court might do today. I'm not even sure she had been charged at the time she entered an alcohol rehab. I know that both the parties were seriously hurt, and I hope that they do recover. And obviously this is not a plea for probation because it's not a probationable offense. She is going to prison. The question is, how long will the court do that? I've heard the state ask for 8 years. I'm not sure all the criteria that the court will look at. There is a minimum of 2 years, which is what I'm asking the court to impose here. Understanding that there are 2 victims. You've looked at her prior record. It's not much to speak of. And she will say a few words to the victim. I know that she asked if I would do the speaking. She doesn't really, one of those people who doesn't like to stand up and speak in front of people. But if you do 2 years, Your Honor, I know this court's position on concurrent sentences, but 4 years is a long time, and she'll do every day of it. The court can't even consider an early release, can't sentence her to a program. It'll be every day, day for day in prison. And she's understood that from the word go. But ask the court to take that into consideration and actually impose the minimum sentence that is allowed and required by law in a case like this. Christine, you can stand up. That's all I have, Your Honor.
All right, Ms. Cassidy.
You can just, if you want to, you know what you want to say to her, just go ahead and then.
Yeah,
Good.
Your Honor, I just wanted to apologize for the incident that happened, and I do not recall it, but I am very sorry to you and your family and for putting you through that. Sorry.
If there's anything you want to tell the
Anything
judge.
else you would like to say?
Yeah, I just wanted, I'm all around sorry for everything. I've never done anything like this and would never have thought about it, but that's it.
All right, anything further?
No, Your Honor.
Well, you know, looking at this situation, I mean, these injuries were very significant, very extensive, and you know, unfortunately, life-changing for your victims. You don't have a previous felony conviction. Yeah, it indicates that you've had some issues with alcohol for some time, and, you know, alcohol was involved in this situation, which is one of the reasons it makes it a mandatory sentence. And, you know, the prison term is mandatory. You're going to have to serve all of it. And you're, what, 34 years old?
Yes, Your Honor.
And, yeah, taking that into consideration, it is the order and judgment of the court that you be and are hereby sentenced to the Ohio State Reformatory Jail Time Credit for women at Marysville, Ohio, on count 1 to a term of 3 years, on count 2 to a term of 3 years, and those are ordered to be served consecutively to each other for a total of 6 years. The court's imposing a consecutive sentence because we have 2 separate victims here that had 2 separate distinct injuries, and the impact on them is different. Even though it was one crash, you know, we have 2 different people with 2 different sets of injuries. And the court feels that one single sentence would not adequately reflect the seriousness of the conduct which resulted in these injuries, and therefore consecutive sentences are appropriate under the law. According to the sheriff who arrested on September the 13th, and been held since then to today. That's a total of 83 days. Now, upon completion of the prison term, well, let me say, the sentence that's imposed on count 1 is a minimum sentence because under the law, the Department of Rehabilitation and Corrections could choose to extend your sentence on that count for up to 1.5 years, as they deem appropriate after they look at your circumstances. So the sentence will be 6 years as a minimum, mandatory minimum, and then if the Department of Rehabilitation and Corrections decides it should be done, they could extend it by an additional 1.5 years as to count 1. Now, upon completion of the sentence, whether it be the minimum mandatory or the extended sentence, whatever is the decision of the Department of Rehabilitation and Corrections. Upon completion of that sentence, it is mandatory that you be put under post-release control supervision for a period of at least 18 months up to a maximum of 3 years, which means you'll be supervised by the Adult Parole Authority by a parole officer under the terms that they set. And if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that offense for under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. It's also ordered that your driving privileges be suspended for a period of 10 years, beginning today. You're also ordered to pay restitution and in the amount of $682.92, and that's to the victim.
Yes, sir, Your Honor.
Okay. And that'll be payable through the victim witness escrow account, restitution account. You'll pay any service fees that are charged with that. And that is a substantive sentence. It's not dischargeable in bankruptcy, and it won't be eliminated simply because you served your sentence. You're also ordered to pay the court costs, which judgment granted and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the sentence, not while you're in prison, but once you get out, you can do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
No, Your Honor.
All right, you're remanded in custody.
Chris, good luck to you. May I approach, Your Honor?
You may. Thank you.
Was that done by a doctor? Did a doctor do that? Okay.
All right, this is case number 23 CR 141, State of Ohio versus Scott Allen Clay. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney William Armentrout. And are you Scott Allen Clay?
Yes, sir.
All right, Mr. Clay entered a plea of guilty to count 1, aggravated trafficking in a fentanyl-related compound, a first-degree felony. The matter was set for a sentencing today. There was no pre-sentence report ordered since this is a mandatory sentence. All right, Mr. King, on behalf of the state.
Only was contained in the plea agreement, Your Honor.
I need you on time. All right, Mr. Armentrout.
And we'd ask to, you can stick up, Scott. We'd ask the court to impose the agreed-upon sentence of 4 years. As the prosecutor just mentioned, it is mandatory, so we'll do every day of it. He pled a while back, and the court gave him some sentencing date for today, and obviously he's shown up. I saw the court, you already noticed he did have a procedure, Your Honor. He would ask, I guess, for like 7 days. He's got an appointment at the doctor at 2 o'clock this afternoon, I believe, to get, I think he does have a staph infection, is what he told me. He needs to get his medication, and I don't know if there's any, I actually don't know what his problem is, Your Honor, if it's a cancerous problem or what, but he would like to have a few days to be able to attend to that.
Mr. Clay, anything you'd like to say?
Yes.
All right. It is a judgment order of the court then that you be sentenced to a mandatory minimum period of 4 years of incarceration, and that could be extended by the Department of Rehabilitation and Corrections to a maximum of 6 years if they decide to do that. According to the sheriff, you were arrested on the 14th of July and released on the 7th of August, and so that would be 24 days of jail time credit. Now, upon completion of this sentence, It is mandatory that you be placed under post-release control supervision under the term set by the Adult Parole Authority, which means, and that will be for at least 2 years, up to a maximum of 5 years. You'll be supervised by a parole officer under those terms. If during that period of time the parole authority determines that you have failed to comply, they can return you to prison and make you serve an additional period of 9 months for any single violation, up to a maximum of half of your prison term for all violations. However, if you committed a felony, then in addition, whatever sentence the judge in your case can impose upon you, that judge is also authorized to sentence you for committing that offense under post-release control, in this case, to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judge will grant an execution order. If you fail to do that, then that can be collected by the clerk through various means, including levying on bank accounts, wages, earnings, or other assets you may have. That doesn't collect it then upon completion of the sentence, not while you're in prison, but once you complete your prison term. The court could allow you to do community service in this county and give you credit for each hour you work, and an hourly rate set by the court each hour you work would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, Your
All
Honor.
right, you're remanded to custody, Mr. Glenn.
I guess that's a no to that then. Your Honor.
Yes. Okay, he's there. Okay, you got his arm, Whitley. All right, this is State of Ohio versus Fred E. Whitley, 23 CR 174. This is a hearing on a sentencing being conducted by Zoom. Are you Fred Whitley appearing there on the screen, marked Fred Whitley? All right. Mr. Whitley's attorney is Danielle Witt, appearing by Zoom from on her phone, and appearing from the prosecutor's office, prosecuting attorney Collins. The defendant has entered a plea of guilty to 4 counts, counts 18, 38, 41, and then 42, which is a forfeiture specification. 2 fifth-degree and 1 fourth-degree felonies, total. The court ordered a pre-sentence report, and I have reviewed that. Now, Ms. Witt, are you and your client both in agreement that he can appear by Zoom here today rather than an in-person appearance in the courtroom?
Yes, we are.
All right, you're all right with that, Mr. Whitley?
Yes, sir.
All right, if any time during this hearing you need to speak with your attorney, let me know, and I'll put you and her into what's called breakout room, where the two of you can speak, and there won't be anyone else that can see or hear you, so that your conversation will be confidential, okay?
Okay, sir.
All right, now, anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor.
All right, Ms. Witt, on behalf of the
Yes, Your Honor.
defendant.
Yes, Your Honor. We also support follow the joint recommendation. Since meeting with Fred, he's been remorseful to me and remorseful for his part in these drug activities and upfront and very cooperative. So we ask the court for him to be able to continue in treatment. He's just been there for a few days, but since the initiation of this case, it was something that he wholeheartedly wanted to do. So we just ask the court for him to be able to do that.
All right, Mr. Whitley, anything that you would like to say?
I did understand, sir.
Is there anything that you would like to say before I pronounce sentence?
Yes, sir.
And how long have you been at TCC?
I've been here a week.
Okay. All right. All right. Well, the court, after review of the pre-sentence report, determines that the sentence suggested in the plea agreement is appropriate. So it's the order of the judgment court, Mr. Whitley, be put under community control supervision by the Highland County Probation Department for a period of 3 years under these conditions. First of all, you must obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your supervision. You must keep them informed of your residence and place of employment at all times, and you may not change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone as an inmate in any of those facilities without prior written permission. That because of your convictions, you're prohibited under both federal and state law from possessing, owning, using, or having under your control any firearm, ammunition, dangerous ordnance, or weapon of any type. And if you were to do so, it would subject you to additional prosecution under both federal and state law. You're not permitted to have any of those items while you're under while you're under community control in this case. You're not permitted to purchase, possess, use, have in your control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any variant analog of any controlled substance or drug of abuse that has effects that are similar to those. Nor may you have an instrument, device, or thing that may be used to administer drugs or prepare them to be administered unless you have a lawful prescription for both the drug as well as the device or apparatus or instrument. And you must provide a copy of that within 24 hours to your supervising officer. You're to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have under control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if that is otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person that has in the past or could in the future influence you to commit a criminal offense or to violate these conditions, unless that's proved in writing by your supervising officer, and that applies to any family members that may fall within that definition other than those you were living with immediately before the offense occurred. After the date of this order, you're not permitted to marry or establish cohabitation or a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law. It's not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any restitution, fines, fees, or costs can be reviewed. If you're referred by the probation department for any treatment or for an evaluation or assessment for any treatment or programming of anything beyond that ordered by the court, you'll submit to that, and if there's a recommendation for treatment, then you'll enroll in and follow that during the pendency of this action. You'll pay the court cost and make payment arrangements to do that with the clerk. You will pay restitution through the probation, through the victim witness restitution escrow account, an amount of $20 a month, $20 a month beginning June 1, 2024. So that'll give you time to complete your treatment and to get the money together, start making those payments. Now, additionally, you'll be required to successfully complete your substance use disorder treatment, which is abbreviated as SUD in the entry, and aftercare at TCC. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property place that's under your control where you're found at any time by the officer of the probation department. You'll execute a written acknowledgement of that obligation. There'll be no fine imposed. There'll be no driving suspension. You'll be ordered to pay. You are ordered to pay restitution in the amount of $240 to the Highland County Task Force. That'll be joint several with Scott Clay and April Koch. If they don't pay their share, you still have to pay the whole amount and try to go after them to collect it. So that $20 that you're going to be starting to pay June 1st applies to that order. You're also ordered to pay the court costs for which a judge will grant execution order. If you don't do that, the clerk can collect that through various means, including levying on bank accounts, waivers, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it is alleged by the probation department that you have not complied with these conditions, there will be a written allegation filed with the court. You'll be given a copy of that. You'll be afforded a hearing. You'll have the right to have an attorney to represent you at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to a term of incarceration on the 3 criminal offenses to a total period of 6 months as a minimum and 42 months as a maximum, and a fine of $10,000. Now, it's also ordered that the property in this forfeiture specification be forfeited to, is that the task force?
Yes, it is, Your Honor.
All right. Let's see, that's count 42. So the property listed in count 42 is ordered forfeited to the Highland County Task Force. Now, in the event that you should be sentenced to a period of incarceration, that would, upon completion of that, it would be possible that the Adult Parole Authority may put you under post-release control supervision for a period of up to 2 years. If they do, you'd be supervised by a parole officer in the terms they set, and if during that period of time they found that you failed to comply, they could return you to prison, make you serve an additional period of up to 9 months for a single violation with a cap of half of whatever prison term is imposed for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in the new case. All right, is there anything further from counsel?
Your Honor. No, Your Honor.
All right, so that completes your sentence, or your case, Mr. Whitley. You're no longer under the trial supervision conditions, but you'll need to contact the probation department to let them know you've been put on community control, and they'll need to go over some paperwork with you.
Okay.
All right, thank you.
Thank you, sir.
Leandro Reynoso.
Yes.
This is case number 23, CR 127. This hearing is a pretrial being conducted by Zoom. You are Alan Reynoso, appearing on the screen marked Alan Reynoso.
Yes, sir.
All right. Mr. Reynoso's attorney is Catherine Hatner, appearing from her office. Well, Ms. Hatner, can you hear me? You need to activate your screen and your video.
Which one? When you got me right, last time I can hear.
Yes, the picture's not right. See,
All right, we lost Ms. Hatner. Text her and tell her to log back in. Does the jail know we're doing Mr. Jameson? Because they haven't logged in. Okay. Yeah, well, we're going to do that here. You can be here. And then also, Mr. Krieger.
Talked this morning, so he's a Marine witness.
Okay. All right, well. But unmute yourself there. All right. Let me go ahead and do that then. Mr. Pollard, I'm going to put you and your attorney into a breakout room, which means that it'll be just the two of you on the screen talking. No one else will be able to see you or hear you. You're going to have to unmute yourself there. There should be a button down in the left-hand corner to click on. It looks like a microphone in red with a slash through it.
Are you there?
Yes, okay. Did you hear what I just said?
Can you hear me?
Yes, can you hear me?
Yes, sir.
Okay. So your attorney wants to speak with you in a breakout room,
Okay.
but hold on here because my screen is not showing a breakout room. Let's see if I can find one. Oh, there it is. On the breakout. No, it was on the... All right, so what I'm going to do is I'm going to put you and him into this breakout room, and there's going to be a button that's going to pop up that shows join breakout room. So you click on that, and then you and he will be on the screen talking. No one else will be able to see or hear you. When you're done, you'll click leave the meeting room, and then you will probably have to log back in. But there should be a button that shows up for that.
Yeah.
All right. So I just clicked on it. Should show up on your screen here momentarily. Mr. Reynoso, I unmuted you a couple minutes ago. So there should be a button on your phone that says unmute. When you click on it, it looks like a microphone with a slice through it. Did you hear me, Mr. Reynoso? Okay, you need to unmute your microphone. I had you on mute a minute ago because we were trying to do another hearing. Okay, case number 23-CR-127, the State of Ohio versus Alan Reynoso. Mr. Reynoso is appearing on the screen marked Alan Reynoso. His attorney is Catherine Hapner. Appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged with one count of a grand theft of motor vehicle, fourth-degree felony.
He's gone.
All right, well, I'm going to go ahead and go forward. Since this is a pretrial, this first pretrial, it was alleged victim made aware of this hearing, the time, place, and purpose, and the right to be heard.
Yes, Your Honor.
All right. This is a first pretrial. Final pretrial is set for January the 3rd. And I believe that the discovery looks like it's been provided by both parties. Is that completed as far as everybody knows?
I don't think I've done my compliance yet.
Oh, I thought you did.
I don't have it either.
Oh, it's a demand. Oh, the demand follows the compliance in the non-linear file. All right. Do you anticipate any pretrial motions, Ms. Hapner?
Not at this time.
All right. And for the record, Mr. Reynoso is now back on the screen. Has there been a written plea offer provided?
Yes, Your
I
Honor.
have received an offer. I've not yet had a chance to talk to my client about it.
All right. Mr. Reynoso, there he goes again. All right. His next hearing will be in person. He just dropped the call again. All right. I was going to ask for him to get in touch with you. Do you have a phone number for him?
I do, yes. And he has been in touch with me. It was before I got the plea offer.
Okay, I got you. All right. All right. Well, then we'll be back on the 3rd, and I said tell your client, since he's having trouble with the signal, it'll need to be in person. All right.
I will let him know.
All right. Thank you. Okay. Now, case number 23-CR-181, State of Ohio versus Christopher Pollard. And you're Christopher Pollard appearing there on the screen. It's Mark Chris Pollard.
Yes, sir.
All right. Mr. Reynoso, you dropped 2 calls, so we went ahead and just did your pretrial. Your next court date will be January the 3rd at 1 o'clock. It'll be in person, so you'll have to come here for that. Get a hold of your attorney since she's got some information she wants to discuss with you. You can go ahead and sign off then. All right. Appearing on behalf of the defendant is William Armentrout. Appearing on behalf of the state is Prosecuting Attorney Collins. This is a final pretrial. The trial in this matter set for January the 21st. All right. So where do we stand on this case, counsel?
My client is accepting the offer. We don't have a prepared to go forward today, but he has indicated to me that is what he wants to do. He would apply for discovery. We can just schedule this for a plea hearing sometime.
Okay. If you want to get a hold of Miss Oyer then, and we'll get that done.
I can do that, Earl. Thank you.
All right. And Mr. Pollard, you're at the treatment center?
Yes, sir.
All right. So if you're agreeable to that, we can also do that by Zoom. So you don't have to drive back up here for that, but you can talk to your attorney about it after you go over the paperwork. Okay?
All right.
All right. Thank you.
See you, Chris. See you later.
Case number 23 CR 210, State of Ohio versus Gary Eugene Seitz. This is a Zoom hearing for pre-trial. Mr. Seitz was indicted for possession of fentanyl-related compound on November the 7th. His attorney is William Armentrout, appearing by Zoom from his office, appearing on behalf of the state's prosecuting attorney Collins. The matter was set for hearing on Mr. Seitz's pre-trial at 2:15. It's now 2:15. He is not present, and Mr. Arjima indicated he is not. You've not seen him since the arraignment.
That's correct, Your Honor, on the 22nd.
Okay. Now today's December the 5th. He was to report once a week for 4 weeks, so that would have been last week. So you've not heard from him, Mr. Armentrout? All right. Well, then the court will order the capias issue for his arrest, and the matter will be put on inactive docket until that time that he is before the court. All right. Thank you. Now, I believe that's the end of the, that's the end of the Zoom docket. Then we got Mr. Krager's in person and Mr. Queen. So,
Are we going to be arraigning Mr. Jensen?
we are. I was going to do that on the video with Mr. Wagner's here and Mr. King's here, so we'll just do it by video. Or do you have? Pardon me?
I'll bring the file over.
Okay, thank you. All right, now, State of Ohio versus Jason R. Krager, 23 CR 201. Present for the state's Assistant Prosecutor King. Mr. Wagner is appearing. Mr. Krager is not. This matter is set for a report on the status of counsel at 2 p.m. It's now 2:15. Mr. Krager is not present. Now, Mr. Wagner, has Mr. Krager retained you?
Your Honor, he has not formally, let me stand up when I address the court, Your Honor. He has formally not. We did speak on the phone today about the terms of my representation. I indicated if the retainer was at my office today, we'd file a notice of appearance and probably vacate today. Otherwise, we'd show up and discuss the matter of my representation versus court-appointed counsel. That's all I can represent. I did speak to him on the phone this morning, Your Honor. I got a good phone number at my office.
Okay, well, if you want to go and call him after we get done with the next case and then see what's going on, and otherwise I'll have to issue a capias for his arrest, I guess.
Really?
All right. You have the Jemison file. We don't have a form for him. Don't have a financial disclosure form.
I can have it faxed.
Yeah.
For Mr. Jemison, Your Honor?
Huh?
Or Jemison?
Yeah.
I've been privately retained.
Oh, you're a private retained. Oh, okay.
Yes.
All right. That's why. Case number 23 CR 229, State of Ohio versus Joseph Lawrence Jemison. And you are Joseph Lawrence Jemison there at the jail? Are you Joseph Lawrence Jemison? Yeah, I can't hear him, officer. Do you have your volume on? There you go. I can hear you now. You are Mr. Joseph Lawrence Jemison?
Yeah.
All right. Mr. Jemison is appearing from the jail. His attorney is Jacob Wagner. He is present in the courtroom and representing the state's Assistant Prosecutor King. Mr. Jemison's been indicted for assault on a peace officer, 2 counts of failure to comply. Mr. King was the alleged victim in count 1, been notified of the time, place, and purpose of this hearing, the right to be heard.
Yes, he has, Your Honor, and he's not present today.
All right. So Mr. Jemison's indicted on count 1 to say first-degree felony of assault on a peace officer. Count 2 and 3 are both failure to comply with the order to signal police officer third-degree felonies. Mr. Jemison was just indicted this morning. Mr. Wagner, does your client waive the 24-hour waiting period and agree to proceed with this matter?
Yes, Your Honor, we would waive a 24-hour waiting period, waive reading the indictment, ask the court to accept it not guilty to all counts. Not trying to get ahead of myself, Your Honor, but I did prelim on this matter, and I've been involved in it for quite some time. We already have typed up and will be filing it today. A motion to have my client evaluated for competency to stand trial. With all due respect, if the court could in any way, I'll say expedite this, or at least the assessment process, it'd be greatly appreciated. I think my client is in much need of some mental health help. And maybe we can get that through the assessment, Your Honor.
All right. You have a motion for that already?
I already have it, sir. I just didn't fill in the case number.
23 CR 229.
229. I have that, sir, and I will file it when I walk down the steps.
Okay. All right, well, let's proceed with the matter of bond. Mr. King.
Has the court received the bond recommendation sheet yet from the state? I know this has moved quickly. I didn't. If not, the state would just ask the bond be set in the amount of $25,000 in this case, Your Honor.
I don't see him on this sheet, Ben. Do you have him on your sheet? All right. What was the bond in the municipal court?
It was, I don't remember exactly, I know it was significantly higher, Your Honor. I thought it was off the top of my head.
Mr. Wagner, anything you'd like to say?
Only, Your Honor, again, I've been privately retained. I've been in contact with Joe's mom throughout this process. It's come to my attention, and I guess I mentioned this due to the, and I think this is probably one of the most severe mental health issues I've had in 22 years of practicing. He's under a guardianship in Clinton County through Judge Carey. There's been multiple cases in Clinton County Common Pleas courts that have been dismissed because of the lack of competency to stand trial. I would ask the court for a relatively low bond, anything that either my client can make or his mother, because we will immediately and will agree to this stipulation. Should he make bond, he immediately go to a mental health facility. That's what we're trying to do from the very beginning. He and his mom and I have reached out to other facilities. We reached out to Twin Valley. I've asked Ms. Sturgill to help. She's been helping me. We've looked at every avenue possible to get this guy out of the county jail and into a mental health facility.
Well, based on the nature of the offenses, my concern is that he's not in a lockdown facility, that he might not appear and might not cooperate with the competency matter. So I'm going to set bond in the amount of $50,000 plus own recognizance. Service fee of $116 be paid prior to release. And then usual conditions, if you make bond, Mr. Jemison, you'll be required to report to the probation department immediately. And then once a week for 4 weeks after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, employer, no contact the alleged victims, recommended by probation, be evaluated for substance abuse or mental health issues, and if any treatment is indicated, you'll follow that treatment recommendation during pendency of this action and be under house arrest at your residence. You also will be required to be admitted to an inpatient mental health facility. If you want to get that motion, and you have it now?
I do, sir. I just need
Let
to
me
make
have it
a,
now. I'll give it to my assignment commissioner, and then she'll contact them, do the entry right away, and contact them and tell them we need to expedite this. Court will find then that the time is being told due to the issue of competency, and so I'm not going to set any trial schedule at this time, and we'll set a hearing on the competency. Will be January 4 at 1 p.m. Yes, you may. All right. So, Mr. Jamison, you'll remain in custody until, unless your bond's made. But if that's the case, you have to go to mental health facility. There will be a doctor get in touch with you to do your evaluation on your mental health. All right. Thank you. Ben, we're going to set the arraignments for people that are in jail for 2:30 Friday. Because I should be back by then. My meeting should be done by noon. All right, this is case number 23, CR 134. State of Ohio versus Joshua Queen, present for the state is prosecuting attorney, assistant prosecuting attorney King, present for the defendant's attorney Danielle Witt. You are Joshua Queen?
Yeah.
All right, this matter was set for a hearing on the motion for intervention in lieu of conviction. Matter's been continued, I believe, twice, and the court director wanted to see a clean test. I have a fax here from Mr. Arjima dated today that Mr. Queen was to come in on November the 21st and did not show. Called to apologize, scheduled another time, and as of December 4th, yesterday, he's not appeared, reported. So I don't have a negative test from since our last hearing, and I assume you didn't show up because you knew you'd be dirty. That's a reasonable assumption. So I don't see any point in doing anything with this then, unless you got something else you want to offer, Ms. Witt.
Unfortunately, I don't think I can, Your Honor.
All right. Well, the court's going to deny the motion for intervention. We'll set this matter for trial. January. Eighth at 8 a.m. And we'll set the final pretrial for December the 13th, next Wednesday. Or is that Tuesday?
Wednesday.
Wednesday? Let's see, are you guys in, you're just there at Columbus Thursday and Friday, right?
I'll be here all week, but
Okay. At 1 o'clock, in person. Report to the probation department, right now. If I don't get a call in the next half hour that says that you are there, I'm going to issue a warrant for your arrest.
All right.
All right?
Yeah.
Get your assignment notice and then get down to the probation department. Okay, back on record on State versus Jason Craig, Mr. Wagner.
Yes, sir, Your Honor. I've had the opportunity, I spoke with Mr. Krieger this morning about my representation and followed back up the phone call today. He was under a misunderstanding that I'd be putting a notice of appearance on. I will be putting a notice of appearance on. He's going to privately retain me in this matter. So he's
Okay.
in Wilmington, but I will get one on tomorrow morning.
So you're going to go ahead and enter appearance.
I will, sir.
All right, then I will not, I'll vacate the oral order that's not been reduced to writing yet.
Yes, sir. Thank you.
And J.D. Wagner is his attorney. And he is scheduled for a pretrial on December the 13th at 2, and a trial date on January 25th, and a final pretrial on the 3rd. All right. Thank you.
Thanks, sir.
I approach, Your Honor.